Well, it's been a week since the end of cash bail in the state of Illinois, and getting some ideas as things, at least in the first week, seem to be going mostly okay as intended, but still some questions about who's able to get out pending trial and who is still languishing behind bars. In Springfield's Morning News, I'm Greg Bishop. You can always follow me anywhere. Just search Bishop on air, and we can connect that way. But on Friday, talked with those who have concerns, but those who are also advocates of this particular law and the Pretrial Fairness Act that was approved way back in early 2021, but then had a few, changes in state law to close some loopholes. And you had the challenge in the Illinois Supreme Court that ultimately had 60 plus states' attorneys from across the state challenging this on constitutional grounds, and a lower court judge blocking it. But after hearing it by the Illinois Supreme Court months after it was supposed to go into effect, they then set the September 18th deadline for that to be implemented after upholding the law. So that was last Monday. Here we are this Monday. But some of the things that we're hearing, of course, looking at some of the conversations that are still being had. Here's a headline out of Chicago. Cook County judges talk about the first week of the end of cash bail. The world is looking at us. There were some glitches in some courthouses in the first week of bail reform, but hearings were slower than usual because of the extensive arguments that prosecutors and defense attorneys have to make under the guidelines of the Pretrial Fairness Act. So you could see that some of the court system may be a little bit more slow in dealing with some of these issues of defendants, how they're going to be treated pre-trial. Are they going to be let go and given, a little note or a text reminder on their cell phone that they got to return to court because they're still a criminal defendant, innocent until proven guilty, but they're still a criminal defendant? Or are they going to be held because prosecutors were able to say, hey, we've got questions about, they're possibly going to be putting the public in danger. They need to be held pending trial. So those are the arguments that prosecutors have to make. Yeah, there's some hiccups, there's some glitches. Some counties necessarily aren't used to this, so they're just now getting into it. And while we'll see in the months ahead how this ultimately plays out, at least for the first week, it seems that things mostly went smoothly, including here in Sangamon County. We talked with Sheriff Jack Campbell on Friday last week, and he laid out some of the things that are going on and how there are actually some criminal defendants still remaining behind bars.
We have a few arrests since then that have also done the same thing. But we're, of the over 50 that have petitioned, 7 have gone to hearing. And thanks to Dan Wright, and I know one of his assistants, Mary Beth Rogers, they've done a great job of arguing. And actually, we're 7 for 7 of these people being detained. So they've had their petition turned down and were able to remain in custody. Well, it runs the gamut. It's a constant influx into the jail. We book in around 15 to 20 every single day historically. And again, that number hasn't changed a lot. So obviously to maintain about a 300 head count, you have almost the same number going out just constantly. So again, we haven't seen that major uptick or downward movement of the head count. So it's just something we're going to have to keep an eye on. It's very early. I've been saying all along that I really believe it's going to take about 3 months for us to really get a good measure as to how this is going to impact our head count, how it's going to impact the crime rate. And believe me, the crime rate is something we're going to stay on top of, along with individuals that we believe would have previously been detained or at least had to post a significant cash bond to see what other crimes they go out and commit. And whatever it is, I want to get it back to you and the other media outlets to let them know what's happening here.
So again, Jack Campbell, Sheriff of Sangamon County, laying out some of his initial thoughts. I connected with Ben Riddell from the ACLU of Illinois to get his initial thoughts on how things have played out in the first week here. Here's Ben Riddell with some of his initial findings.
Well, I think we've heard reports from different parts of the state and some of which we have incomplete information. And so I don't want to call out any particular court systems or actors, but, certainly we have heard, some reports of issues coming up here and there. But, we have to remember that Illinois didn't just end money bail. It transformed the entire pretrial system. And so with cases being given a more meaningful review, that it's a process and that we're going through right now. But overall, it's been smooth. But certainly there are going to be hiccups. But we have seen, that the need for investment in public defense has become even more apparent. So it's essential that moving forward that our state invest more resources to ensure that everybody is able to access meaningful representation when they're accused of a crime. So I think that's one issue that I would lift up.
Riddell talking about the issue of having public defenders and enough public defenders, and he said previously that that's an issue that's been around since before the end of money bond. And Riddell talking about, the various ins and outs here as to watching this moving forward and how this is, meant to let low offenders released pre-trial to come back for their criminal defense, while also keeping more dangerous people, as Jack Campbell had said, of 50 that had applied, that had hearings for 7, and he said those 7 were kept behind bars. Among those cases in Sangamon County included conduct endangering the life of a child, vehicular hijack, and even aggravated battery of a correctional officer and escape. So Riddell talks about how the law, no cash bail, it's meant to, essentially do that, to allow for low-level criminal defendants to be released because they're innocent until proven guilty. But you also have those who are innocent until proven guilty, but prosecutors can prove might still be a threat to the public. They're going to be held behind bars.
Well, I think that we always understood the goal of the Pretrial Fairness Act, along with, doing away with the financial, the economic inequity of determining pretrial incarceration based on the how much access to wealth somebody has, is that that we're currently overusing pretrial incarceration, and that there are too many people in jail who ought to not be there. And so it was always our goal that jail populations decrease, and we think that will happen, but also an understanding on our part that that going to an in or out system where there is no ability to secure one's release once they're detained by paying money, at least, would change the composition of who's in jail, and that people who are charged with more serious charges, especially those that implicate safety of others, would potentially that we would see an increase in the detention of people who are charged with those kinds of things, while people who are charged with nonviolent charges, drug possession, shoplifting, that are typically subject to money bail under the old system, that we'd see more people being released who are charged with those kinds of things, and nobody's release being prevented by the fact that they don't have a certain amount of money. So, we'll see. I think it remains to be seen what the overall trends will be, but we believe that the law is appropriately crafted to affect an overall decrease in the jail population, and to release people who should be released, who were not being released solely because they didn't have access to money, while giving courts the tools that they need to utilize in order to try to protect the safety of victims and survivors in the community, and that in some cases would result in people being detained in jail who might have otherwise been able to secure their release through payment of a money bond under the old system.
So some of the critics, though, point to a recent case of some criminal defendants getting caught with 5,000 pounds of illicit cannabis, and they were practically released after being booked. And I think they were from out of state. Are they really going to come back to Illinois to face charges? I guess that means some sheriff's deputies are probably going to have to work with other states to try to bring people back in order to face criminal charges if indeed that type of thing happens. So, there's going to be loopholes found that they need to close. So we'll see how that plays out. But ultimately, still some questions because while you've got low-level offenses, having people released, more serious offenses, people being held, there's another class of jail prisoners that are being held that both sides of this equation say shouldn't be. And I'll tell you about that coming up next here. And those are unfit for standing trials. Stay tuned. We'll get to that next here with Springfield's Morning News on WM. While courts across the state continue to evaluate how they're implementing the Pretrial Fairness Act, the end of cash bail, you've got questions still looming about those who are still lingering behind bars, and despite them being found unfit for trial. And we talked with Sheriff Jack Campbell about that last week and the week before, and we've talked with him about it months ago. It's an issue where they have sued time and again and found the state in contempt of court for not following the law, and they ultimately changed the law, as Campbell says, to give cover to the Illinois Department of Human Services. But it's a problem here in Springfield and across the state. Here's Sheriff Jack Campbell talking about that.
It's still status quo. It's just what it did was it gave them cover that they're not violating the law anymore. They were held in contempt a couple times in Sangamon County courts, DHS was, and all this did was give them cover. But in the end, again, if it gave them cover, it still does not do anything for these inmates. It just made them look better, and they were no longer going to be held in contempt. So politically, it looks better on their end. It changes nothing about the head count in all of our jails. And by the way, Dr. Coleman said there are about 200 statewide that are sitting in county jails that need to be in DHS facilities. So again, we are not taking care of these inmates, and that's our ultimate goal, is to make sure they get that need. It's simply not our job. We do it, and look, we spend a lot of money on mental health care treatment. And like I told you before, we have about 100 inmates that have serious mental health issues. And then if you're focusing on the 4 or 5 that are declared unfit sitting in our custody, the other 95 are not getting as much treatment as they would normally get. So that is one of the things we're trying to resolve also.
So obviously still some concerns about the inmates in county jail charged with crimes that are found unfit, meaning they can't mentally stand trial right now, and they're supposed to be taken to an Illinois Department of Human Services facility to be evaluated and to possibly be rehabilitated to a degree to be able to face trial. But instead of going to where there are dedicated staff and beds to treat somebody's mental illness, you got 200 across the states that are lingering behind county jail walls, not getting the level of treatment you would expect at a mental health facility. Instead, you've got jailers providing some of these things, and that diverts the attention away from others who may need certain types of help. Well, the ACLU of Illinois' Benjamin Riddell, again, he sounded off on this particular issue in reference to the overall jail population.
I think certainly, jail populations are of concern, and people who have been deemed unfit to stand trial, shouldn't languish in jail forever. There's supposed to be a process for bringing people to be able to competently testify in court or to stand trial. And I think some of those, they're complicated issues, some of which have, some of the factors may include the availability of placements in therapeutic environments. I broadly speaking, I'm not prepared to propose specific solutions, but I think it's something that has been a topic of conversation in the General Assembly, and I think there's general consensus that jail is not the place for somebody who's experiencing serious mental health issues, and that those that are experiencing those issues should be in a more therapeutic environment, whether it's to restore their competency to stand trial in a criminal case or for any other reason.
So again, while a lot of focus on criminal defendants being able to get out because they can't afford bail, You've got the inmates in county jails, 200 or so across the state, that are found unfit, meaning they have some kind of mental condition that doesn't allow them to stand trial, languishing behind bars, and the humanitarian questions and the taxpayer cost questions, all of that still lingering while you've got the Pretrial Fairness Act playing out. So all of this we'll be watching, of course, because criminal justice is important to get right. And I think it's obviously a point of discussion that's going to be had at the Illinois State House, and we'll be tracking that the best we can for you as well. Follow me anywhere. Just search Bishop On Air. Again, Bishop On Air on X, formerly known as Twitter, on YouTube, on Facebook, and we can connect that way. You can also email me anytime, bishoponair@gmail.com.